Assalamualaikum and hi, we are from Group 9. We'll be presenting the case of Sul Hamid bin Pakir Muhammad against Inspector Abdul Fattah bin Abdul Rahman and Anwar 2007 6 MLJ 47. So this case ended at Court of Appeal in Putrajaya and the date was on 20 July 2007. So our case highlighted about the procedure of arrest in criminal cases. So in this case, we will determine whether the offences committed by the appellant is seizable or non-seizable and whether the arrest should be with warrant or without a warrant. So let's go. Generally, arrest is the starting point of criminal justice, where the police arrested the suspected person for commission of an offense. So the word arrest here literally means deprivation of personal liberty by legal authority. Or in other words, I would say that it means the apprehension of a person by legal authority, which resulting deprivation of his personal liberty by legal authority. The procedure of arrest here are laid down in Criminal Procedure Code, and there are several things the arrestor should be considered before arresting someone to ensure that the arrest is lawful.
Now, I will talk about the summary of Sul Hamid against Inspector Abdul Fattah. In the case of Sul Hamid bin Pakir Muhammad against Inspector Abdul Fattah bin Abdul Rahman, the appellant at the material time was a technician who worked at the Botanical Garden, Penang. The first respondent is a police inspector who serving as an investigating officer at Pulau Tikus Police Stations in Penang and an employee to the second defendant, which is the government of Malaysia. There were two police reports lodged at the first respondent's police station. The first police report was lodged by Sukah Singh, a 13-year-old Indian boy. He alleged that at 10 a.m. on 31st March 1987, while he was selling peanuts at the Botanical Garden, Penang, the appellant, who was riding a bicycle, suddenly knocked into him, and because of that, he fell. According to the Sukah Singh letter, the appellant hit him with the appellant's hand and asked him to bring out the money from his pockets. The second police report was lodged by the appellant himself, who is 33 years old. In his report, the appellant alleged that on the same day at 10:30 a.m., Sukah Singh had blocked his way and threatened him by saying, "You cannot work here." Later, at 12:40 p.m., when the appellant on his way back, Sukah Singh and his two brothers suddenly appeared and shut the gates. The appellant was unable to avoid the gates and crashed into the gates. Then he fell and was injured. The appellant further alleged that Sukah Singh and others had attacked and kicked him. The first defendant chose to believe the report made by Sukah Singh over the appellant's report and arrested and detained the appellant on 31st March 1987 for investigations. So the appellant was charged for two offences, which under Section 392 of the Penal Code for the offence of robbery and under Section 323 of the Penal Code for the offence of voluntarily causing hurt.
Okay, next I will explain about the issue of this case. So there are three issues raised by appellant counsel which are concerning about the arrest of the appellant. The first issue is whether the respondent had power in arresting the appellant for non-seizable offence under Section 323 of Penal Code. The appellant claimed that the respondent had no power in arresting him without a warrant, as the offence under Section 323 fall under non-seizable offences, which will need a warrant if want to arrest him. The second issue is whether the first respondent had reasonable suspicion to arrest the appellant. So this issue related with section 23 subsection 1 paragraph A of Criminal Procedure Code, where it gives a power to police to conduct an arrest without an order from the magistrate and without warrant if there is reasonable suspicion against the arrested person. Therefore, the appellant here claimed that the first respondent had no good reason or urgent to arrest him. So the third issue is whether the police could have carried out an investigation and charged the appellant without having to arrest and detain the appellant. So the appellant here alleged that the police could have carried out an investigation without having to arrest and detain him.
Let's move on to the judgment. As to the judgment and legal reasoning, Abdul Aziz Mohammed Jasir delivered that the majority of the court dismissed the plaintiff's appeal with cause and ordered the deposit to be paid to the defendants on account of tax costs. They upheld the orders granted by the High Court and provide their reasons. Firstly, the court ruled that the arrest made by the first respondent was lawful. The appellant's separate offence did not affect the lawfulness of their custody, while the appellant committed a non-seizable offence under Section 392 Penal Code and allegedly caused hurt under Section 323, which is a seizable offence. The court reviewed this action as part of one transaction. The appellant's act of taking money was seen as theft. Referencing Section 390 subsection 2, the court noted that the theft becomes robbery only if the offender caused hurt to someone during the theft. Since the element of causing hurt was in question, the court concluded that the appellant's detention for robbery remained lawful.
The second, the court found that the appellant had indeed committed the alleged offence. Suka Singh, one of the key witnesses, was deemed truthful, largely due to the appellant's failure to cross-examine him or other important witnesses. The court also determined that the police did not abuse their power in making the arrest. Instead, their decision to arrest was based on a careful assessment of various factors. Although the appellant's counsel presented arguments to challenge this, the court ultimately disagreed, concluding that the counsel had failed to provide sufficient evidence to support their claims. And the last is, the court upheld that the police officer's decision to arrest the appellant was reasonable. While the appellant's counsel relied on Lord Devlin's statement to argue that the arrest should only occur when absolutely necessary, the court clarified that this does not mean arrests based on reasonable suspicion were invalid. The judge emphasized that arrests based on reasonable suspicion are lawful, even in the absence of prima facie proof of this alleged offence. The police had considered factors such as the physical differences and behavior of the parties involved, which justified the arrest. As a result, the court concluded that the arrest was lawful and did not amount to false imprisonment.
Okay, so in our opinion, we agree with the judgment given by the court in this case. The first reason is, as the appellant had been arrested for committing both seizable and non-seizable offences in the same transaction, it is reasonable for the police to arrest the appellant without warrant for non-seizable offences. Secondly, we agree that the police had reasonable suspicion to arrest the appellant, since based on the evidence stated that Suka Singh is only 13 years old kid and he's only 4 feet taller compared to the appellant, which was much more taller, burly, and heavily built. So an ordinary people would believe that in this situation, Suka Singh was most likely to be the victim, not the appellant itself. Okay, lastly, we also agree with the decision of the court saying that the act of the first respondent, which carrying out an investigation without a warrant, is lawful. This is due to the police discretion being essential for preventing harm and facilitating investigation, and also to constitute an arrest So, we believe that reasonable doubt raised is enough for the police to carrying out an investigation.
For its significance, there are three main significant. The first one is it highlights the broader powers of law enforcement to prioritize public safety when multiple allegations come from the same transaction. Secondly, it upholds the principle that arrests based on reasonable suspicion are critical tools for maintaining public order while ensuring that police discretion is exercised within legal bounds and subject to legal procedure. Lastly, it reinforces that police actions are presumed lawful unless there is clear evidence of abuse or misconduct, protecting officers from baseless accusations while ensuring accountability.
That's all from us. Thank you. Bye.